Hi, Douglas Rosenthal of the Rosenthal Law Firm back with you again. Today I'd like to speak with you about a immigration relief called cancellation of removal. Perhaps you've heard of cancellation of removal, but you are not entirely familiar with it, and I'd like to go through the criteria for cancellation of removal and offer you some tips for success with regard to it. Cancellation of removal is a relief which basically has with it three particular elements or factors that you must be able to prove to an immigration judge before the immigration court. The first factor is you must have been in the United States for 10 continuous years before you can apply for cancellation of removal. Another element to cancellation of removal is being a person of good moral character, and we will discuss exactly what constitutes good moral character in just a little bit. Finally, and perhaps the most important element of cancellation of removal, is you must have a U.S. citizen or permanent resident, spouse, parent, or child, and that is called the qualifying relative. And if you were to be removed or deported from the United States, you must be able to prove satisfactorily to the immigration judge that that qualifying relative will experience what is called extreme and unusual hardship, and we will define that and explain that term in a little bit as well. Now, cancellation of removal, you must understand, is a risky form of relief. Why? Because you can only apply for it in removal or deportation proceedings before the immigration court, which means that you first have to put yourself into the jurisdiction or the power, be under the power of the court, and then you must apply for it. So you must be very confident that you have a very significant and meritorious case prior to deciding that you want to file for cancellation of removal. Now, cancellation of removal has been described by an immigration judge as being essentially a document-heavy case. That means that the judges rely primarily on the documents that you submit to prove the elements that I've just described, as opposed to listening to a lot of testimony. As a matter of fact, I've recently had a cancellation of removal case that I was able to win on behalf of my client without the client having to testify for more than perhaps 10 minutes. The immigration judge reviewed all of the documents before my clients came into court and was able to determine that all of the elements were satisfied, for the most part, prior to taking any testimony. Now, let us discuss what is considered to be a qualifying relative and extreme and unusual hardship. Extreme and unusual hardship is not regular hardship, which means that any time that a parent is removed from a child, or any time that two spouses are separated, there obviously is some kind of hardship that is involved. However, this is something that goes beyond. That's why it is called extreme and unusual or exceptional hardship. It is a level and a burden that you must prove higher than ordinary hardship. And what courts often look for is to see whether or not the children have problems with academics, education in school, and therefore it is important to bring academic records and school records, transcripts, letters from teachers, or from the school that the child is attending. Likewise, if there is a medical situation or problem which is unusual and requires treatment and therefore would require the presence of the applicant, that would also perhaps be deemed to be an unusual and extreme hardship. Now, you must not overlook the fact that it contains with it a component of good moral character, because good moral character requires not only that you not have been arrested for any crimes, but also that you have paid taxes while you've been in the United States. I've had clients that have been essentially found to be of not good moral character for failure to pay taxes, or for paying taxes on less money than they in fact earned, or declaring less money that they earned. Also, the payment of child support and the proof of payment of child support is a very important factor towards proving good moral character. Another and the final element with regard to the 10 years of continuous presence, that requires documentation as well. You must be able to document for the immigration judge that you have been in the United States for 10 years, which means you would have to show such documents as receipts for lease payments or other documents dated that show that you have not left the United States for more than a period of 90 days, but even periods for as little as 2 weeks have been questioned by the immigration judge, and that will allow you to have a good chance of success at your application for cancellation of removal. Our office has successfully, as I mentioned, represented cancellation of removal clients, and we would be very happy to represent you. Remember, my name is Douglas Rosenthal of the Rosenthal Law Firm. We're located in downtown Manhattan at 350 Broadway, a block and a half from the Immigration Building here in downtown Manhattan at Federal Plaza. Our telephone number is 212-625-8300, and we look forward to answering your phone calls and to guiding you through this process of cancellation of removal. We would be happy to hear from you and answer your questions. Please give us a call now. Thank you.